Thanks for coming, everybody. In terms of order, we're going to have Michael Savell speaking, who's currently going through a court case. So he's going to talk about his experiences of going to court and the kind of strengths and weaknesses and lessons learned from that. And after that, we're going to have Georgina Hollis and Amar Chauhan from Find Others, who've been our campaign partners throughout this campaign. So they're going to talk about the platform that they've launched that is really helping us move this campaign on to the next level, really. I'm going to talk very briefly just about other campaign tactics that we can use. And after that, we'll open up the floor, the discussion to the floor and really agree the next steps for everybody. And then, we'll sort of summarize the action points at the end. So let's go first to our first speaker, Michael Savell. Are you there, Michael?
I am, yeah. Good evening.
Over to you, Michael. Thank you.
Thank you. Right. Good evening, everyone. My wife and I moved into Houghton Court in southeast London in December 2013. And at the time, this was managed by Viridian Housing. Houghton Court is a new build of 170 flats, specifically for people over the age of 55. Initially, there was supposed to be 20 leasehold and 150 apartments for rent. The leasehold / shared ownership number was reduced to 12 when Viridian were unable to sell all of them. I first noticed a problem with our service charge account when the first statement arrived, showing a personal gas charge of £22,000 on the account. This was for the whole building, not just our apartment. The problem was that we do not have any gas at Houghton Court, except what goes into the commercial kitchen and to the plant room that supplies the hot water that supplies heating to the individual apartments and is paid for by the tenants on a metered basis. With the support of the Committee of the Residents Association, I raised this with the management of Viridian and then spent 2 years negotiating with them to get it removed and refunded. During this time, Viridian were involved in merger talks with Amicus Horizon, which led to the formation of Optivo Housing. At one of the pre-merger meetings with residents, we were told that Amicus Horizon had the best service charge team in the industry and disputes about service charges would be a thing of the past. Unfortunately, this was not the case, and in fact, things went downhill quite rapidly. The senior management of Optivo did not want to engage with me or the other residents in trying to resolve the issues and would not acknowledge that there was a problem. A leaseholder had at this time made an application to the first tier tribunal, but was unwilling to include the renters on the application. In his view, the application was firstly for him, then the other leaseholders, and finally, when he won, then the social housing tenants would benefit. I'd like to make it clear at this point that this approach does not work. Applications to the FTT are individual or for a group if it is a joint application. Any judgment obtained either in favour of the applicant or dismissing the application only applies to that applicant. So if you make an application in your own name and you win all of your money back, unlikely, the respondent only has to pay you back, not the other residents, unless the housing association decides it's the correct thing to do. Then everyone benefits from your hard work. My wife and I called a meeting of the residents to gauge the amount of support for an application and managed to secure the support of 102 out of 200 residents. And we made an application to the FTT in September 2020. It was only after the application had been made that Optivo wanted to talk to us. And following the directions of the judge, we received copies of all invoices charged to the service charge accounts for the year 2018-19. Optivo's solicitor suggested in December 2020 that we jointly apply to the judge for the application to be paused to allow us time to try and reach agreement on the outstanding issues. We agreed and the judge agreed to pause the application for 3 months. We then jointly agreed to continue the pause as we'd made some progress on the errors that we found and refunds were agreed on some of the overcharges. We have so far secured over £318,000 in refunds, just to let you know. During this time, the following year's accounts arrived, and they also contained further glaring errors and overcharges. Once again, we were able to agree with Optivo that the overcharges should be refunded, but it took a lot of hard work, long meetings, and patience. We have two main issues outstanding: energy costs and staff costs, both of which have increased out of all proportion since the current management took control. As we have been unable to agree a compromise, I have asked the FTT to lift the pause. I asked the FTT to lift the pause in May 2022 so that we could proceed to a hearing. It would have seemed that something has gone wrong at the FTT, because after 4 emails and any number of phone calls, I found out today that my requests have not been sent to a judge. And I found out, sorry, that was yesterday. And I found out today that the judge has given Optivo until the 1st of March to agree to lift the pause or give reasons why they don't agree. I assume that Optivo will agree to go to a hearing, so now the work begins to put the case together. And although people are happy to support you, that does not translate into them being willing to help prepare the case. The tribunal system is supposed to enable a layperson to have access to justice for a relatively small cost. In practice, it takes an enormous amount of work to prepare the case, and if when you get a hearing, you will be faced with barristers and solicitors representing the housing association, many of whom will already know the judge. If you do decide to go for an application, you will need the following: a well-prepared case with proof of wrongdoing, the support of as many other residents as possible. Ideally, make a joint application on behalf of all classes of tenancy, i.e. shared ownership, leaseholders, and social housing renters. Thirdly, lots of time and patience and the willingness to see it through to the end. Alternatively, you could instruct a solicitor, if you have £45,000 to £50,000 spare, to fight the case for you. That's how much we were quoted. You will be threatened with costs if you lose, unlikely to be granted unless your case has absolutely no merit or you have refused a reasonable settlement. You will probably be faced with a patronising barrister who will try and dismiss your arguments on the grounds that you don't understand the law. My view is that the tribunal system is unfair on applicants, as they don't have the expertise to prepare a case, and there does not appear to be any help available to make it less one-sided. Unfortunately, the only alternative currently available is to just accept anything the landlord wants to charge and pay up and shut up. Having said that, I would encourage anyone who thinks they have been overcharged to make an application to the FTT, especially if you can get the support of neighbours, because the more landlords see that their tenants are prepared to challenge them, the more chance there is that they will take a bit more care of your money. Thank you.
Brilliant. Thank you. Thank you very much for that, Michael. And good luck to you with the ongoing case. So we look forward to hearing how it goes.